We didn't become plaintiff-side employment lawyers because it was easy. In fact, I think many lawyers will tell you that being a plaintiff-side employment lawyer is one of the hardest areas you could think to get into. And the reason for that is, we're faced with oftentimes proving intent. So what was a decision maker's intent when they selected a person for a layoff or for a termination? And discriminatory intent is obviously when it is there, it's something that also is concealed. So it's a hard thing to prove, and you need to be very diligent in how you prosecute a case in order to be successful in this sort of situation.
Yeah, when we take on a case, we, thinking like a basketball analogy, we want to put on a full court press, because from one end of the court to the other, there are opportunities to get an advantage, and we like to do that up and down. And yeah, just going on the basketball analogy, we know we can't turn the ball over. We have to be perfect the whole game, and we strive to do that.
Another way to look at it is, we have very few clients that come to us and say, I want to have a trial. Usually we have clients that are coming to us and saying, I feel like I've been wrongfully terminated. I have no income. I'm worried about my medical benefits. And they're coming to us actually to try to, hopefully negotiate a settlement if we can. One thing that we've endeavored to achieve is essentially to have our successes and the hard work that we've done for our previous clients translate into better successes and results for our current clients. And I think we're starting to see that, where the defense attorneys in town know the playbook that we use, and can consult with their client and let them know what's coming, because 9 times out of 10, the correct business decision for the company is to resolve this case early. What's startling to me is how often defendants' personal emotions can cloud their judgment, and it can take a while with us holding a mirror up to that defendant or the decision makers for them to realize that they've got a problem. The other thing we've tried to establish in town, in the companies that we've been up against, is that the longer and harder you fight us, the more it's going to cost to settle the case. It's not uncommon for, at the end of, say, summary judgment briefing, or if we've survived summary judgment, for an employer to pay a multiplier of 5 or 6 times more than they could have if they just settled when we represented a client in a negotiations on a severance package. So it's a hard job being a plaintiff-side employment lawyer, but it is so rewarding. We get rewarded with hugs from our clients. We're helping the little guy against a corporation that has more money than God, basically. And that sort of David Goliath underdog scenario, I think, fits perfectly with, my personality and then Sean's personality. We wouldn't want to be anything else but representing the underdog. We love what we do. When I'm driving to work in the morning, I might be a little tired, but then I think about what a privilege I have to be able to help people that have been sexually harassed or wrongfully terminated at work. And for me to be a part of the community and to be able to do something about that is a privilege, and something that I take a lot of honor in, and I know Sean does too.
Yeah. One of my favorite parts of the job is, Josh talked about the David Goliath dynamic, and our clients are certainly on paper, the underdog, no doubt about it. We represent the underdog on paper. But when I go to work, I don't feel like it. I don't feel like I'm the underdog in these cases. And I love that, because we compete on the same stage, and we do very well. And I relish that opportunity, and I love what I do.